ATFs engaged in the business as a dealer in firearm rule is now in effect. So I hope you took advantage of this past weekend and sold anything you wanted to sell. If not, you may still be protected from ATF's latest infringement. So be sure to stick around to find out more. Happy Monday and welcome to the Firearm Firm channel. I'm attorney James Phillips, and ATF's engaged in the business rule went into effect today. But we do have some breaking news that came out this past Friday to share with everyone. But before we do, be sure to take a second and hit that like button. And if you have not already subscribed to the Firearm Firm channel, please take another second and hit that subscribe icon located down below in the bottom right hand corner of this video. All right, like I said, ATF's rule that attempts to try and make anyone selling a gun dealer, and therefore requiring them to obtain an FFL before doing so, is now in effect. If you are just now hearing about this rule for the very first time, I don't know where you've been hiding, but if you haven't heard about it, be sure to click on the link above to watch our video discussing the rule. So this past Friday, I did a video discussing 3 lawsuits that were all filed on May the 1st challenging ATF's final rule. Well, late Friday, one of those lawsuits got a preliminary injunction entered against ATF, preventing them from enforcing the rule. So let's spend a couple of minutes today and talk about this preliminary victory. So the lawsuit I'm talking about is Texas et al. Versus ATF et al., which was the second lawsuit filed against ATF. Now, if you've been following this channel at all, you know that the Northern District of Texas understands what shall not infringe means, and they thoroughly seem to enjoy spanking the ATF. So the judge in this case entered a temporary restraining order restraining the defendants from enforcing the regulation definition of engaged in the business as a dealer in firearms against the plaintiff Texas, Jeffrey Tomey, Gun Owners of America, Gun Owners Foundation, the Tennessee Firearms Association, and the Virginia Citizen Defense League, which will remain in effect until June the 2nd of 2024. Now, in order to obtain a preliminary injunction or a temporary restraining order, the plaintiffs are required to show 4 things. 1, there is a substantial likelihood of prevailing on the merits, which probably is the most important thing. Number 2, a substantial threat of irreparable injury if the injunction is not granted. Number 3, the threatened injury outweighs any harm that will result to the non-movement, which in this case is ATF, if the injunction is granted. And number 4, the injunction will not disturb the public interest. So the court in this case found that there is a substantial likelihood of prevailing on the merits, and in their order, the court wrote, the final rule clashes with the text of the Bipartisan Safer Communities Act, the BSCA, in at least 3 ways. First, it asserts that there is no minimum number of firearms to actually be sold to be engaged in the business for the purposes of licensing requirement. A single firearm transaction or even a mere offer to engage in a transaction may suffice, but the Bipartisan Safer Communities Act says otherwise. The term engaged in the business means, as applied to a dealer in firearms as defined in section 921A11A, a person who devotes time, attention, and labor to dealing in firearms as a regular course of trade or business to predominantly earn a profit through the repetitive purchase and resale of firearms, but such terms shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. Defendant's proffered interpretation is severely undercut by section 921A21C, use of, number 1, firearms in the plural. Number 2, the phrase regular course clearly contemplating a series of events. Number 3, repetitive meaning more than once. And number 4, the section's exemption of sales, exchanges, or purchases in plural. So too does section 921A21C require the purchase and resale of firearms, a conjunctive requirement that flatly contradicts the defendant's assertion that there is no minimum threshold number of firearms purchased or sold that triggers the licensing requirement. Second, the final rule suggests that actual profit is not a requirement of the statute. It is only the predominant intent to earn a profit through the repetitive purchase and resale of firearms that is required. In other words, A person may repeatedly advertise and display firearms for sale and therefore demonstrate a predominant intent to earn a profit from repeatedly reselling the firearms purchased, but never actually find a buyer. But Section 822 of the Bipartisan Safer Communities Act provides the term to predominantly earn a profit means that the intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain as opposed to other intents such as improving or liquidating a personal firearms collection, provided that proof of profit shall not be required as to a person who engages in the regular and repetitive purchase and disposition of firearms for criminal purposes or terrorism. The negative corollary is obvious. While proof of profit is not required for criminal purposes or terrorism, it is required for all other cases. Moreover, the mere fact that the word intent appears in the section does not necessitate or even suggest that intent is all that is required. On the contrary, the section's usage of intent serves merely to distinguish the type of intent contemplated, namely one of obtaining pecuniary gain. Action is needed too. Third, the final rule arbitrarily eviscerates Section 921A21C's safe harbor provision, which reads, "The term engaged in the business shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms." The court went on to note that nothing in 18 U.S.C. 921A21C suggests that the term personal collection does not include firearms accumulated for personal protection. Yet, that is exactly what ATF's final rule asserts. The court also took issue with the final rule's presumptions indicating when a person has the intent to predominantly earn a profit and that someone is engaged in the business. As to this, the court wrote, "These presumptions are highly problematic for two reasons. First, they flip the statute on its head by requiring that firearm owners prove innocence rather than the government prove guilt. Second, several presumptions conflict with the statutory text found in the Bipartisan Safer Communities Act. The court found that it was hard to dispute that the plaintiffs would not suffer irreparable injury absent an injunction. The court found that the plaintiff, the state of Texas, faces the irreparable injury of revenue loss, while the other plaintiffs face both civil and criminal enforcement actions for engaging in a conduct that the Bipartisan Safer Communities Act permits, but ATF's final rule impermissibly forbids because they cannot dispose of firearms from their personal collections for fear of being presumed engaged in the business. The court found that the plaintiffs also met the last two factors that are needed to obtain a preliminary injunction or a temporary restraining order. I will attach a link to the order in its entirety down below for anyone that wants to read it in the description section. Now, those that watched the video on Friday discussing the three lawsuits may be thinking, wait, I thought Mississippi, Louisiana, and Utah were part of this lawsuit. And you would be right. So why did I not say that this temporary restraining order was applied to them in the beginning of this video? Well, the court found that Mississippi, Louisiana, and Utah failed to establish standing. So, unfortunately, they are not afforded the protection of this temporary restraining order. Well, ATF is going to appeal. I have no doubt about that. They appeal everything and they're going to appeal this. But unfortunately for the ATF, the appeal will be headed to the 5th District Court of Appeals, which has consistently ruled in favor of we the people and not for those tyrants. So good luck with that, ATF. Be sure to let us know what you think about this victory down below in the comments section, along with any questions you may have about this video or any other Second Amendment related issue. Until next time, stay armed and educated.